able to bring you this session today. The recording's in progress. Where our session today is going to address the deeply important issue of challenging unreasonable delay in family stream visa applications. We have three absolutely exceptional speakers for you. We're going to introduce them all individually, but just to give you a taste, we've got Zabi Mazoori, who's an exceptional human rights defender, who's worked extensively in Afghanistan and with the Afghan diaspora. He's going to speak to us today about family separation and what this means on the ground for people who are living in our community. We've got Ben Mostafa of Council, whose bio is so long that we've had to devote a separate section to it, who led the Human Rights Law Centre's challenge earlier this year on behalf of an Afghan family, and who will address the principles governing the assessment of visa applications and identifying unreasonable delay. And we have my excellent colleague, Josephine Langbein, a senior lawyer at the HRLC, who will take you through the details of the case that we ran, what we learnt from it, what the pitfalls were, and the ultimate successful outcome. I'm going to very briefly discuss, in no way to discourage anybody, but very briefly discuss and flag some of the challenges and the risks involved in bringing litigation for people. We're going to have time at the end for questions, but because we're presenting this in a webinar format, we're going to ask you to type the questions in the chat and we will take and read out as many as we can, but we are keen to take questions on notice and we're more than happy to if we don't get to them today. The idea of this session, as we said when we sent it out, was to essentially create a community of practice, to share resources, which we're happy to provide after the session, and to encourage others to bring proceedings of this nature, and also to connect with us if they're looking for lawyers and looking for counsel to bring these proceedings, because as you'll soon see, we think that this is an exceptionally important issue that's affecting thousands of people. So before I introduce you to Zabi, I'd like to just give you a brief snapshot of the issue that we're talking about today and its importance, and just the number of people who were caught up in the systems that we're describing. So just bear with me a second, I'll take you through the slides. Yep. Hopefully you can see that. I can see it in a very tiny way. Hopefully you can too. Not to inundate you with statistics, but I've set out some here. So what we know is the following, that the average processing time for offshore partner visa applications made by citizens of Afghanistan that were decided in the last program year was around 36 to 60 months. So those applications that were decided in the last program year had been pending for that amount of time. I haven't given you a snapshot of other countries, but just to give you an example, the offshore partner visa application standard processing time for citizens of the US and the UK was around 12 to 14 months. So the delay is impacting particular national cohorts and is just extraordinary. It's by a significant multiplier. The number of pending offshore partner visa applications as at the 1st of July 2021 is approximately 70,000, and approximately 40,000 applications are being lodged in every program year. In order to combat some of these issues, in March 2021, the department established something called the Middle East Onshore Complex Team, so the MEOCT, and around 8,000 applications, partner visa applications, other family stream applications have been repatriated from the offshore posts to the MEOCT that has, according to Senate estimates responses, around 19 staff. I'm sure they're doing their best, but they've processed a very small proportion of visa applications, around 1,500 in the previous program year, and they have many, many more currently in the process of being repatriated to them. So that section there, so far as we know from an earlier meeting this year, continues to have applications on hand that were lodged in 2013 by citizens of Afghanistan. That is almost a decade. That gives you an idea of how long people have been waiting for very, very simple visa applications to be decided. And of course, we know that just earlier this month, the Minister for Immigration and Citizenship announced that there would be a series of goodwill measures that would be of benefit to so-called former unauthorised maritime arrivals, including amendments to, that's how it was described, Direction number 80, Ministerial Direction 80, in accordance with which family stream applications sponsored by people who arrive by boat and a permanent residence are given the lowest level of priority. So we're going to discuss later in the session, that is, of course, a welcome and a beneficial announcement, but is not going to change, of course, the level of delay in assessing these applications, and is simply going to mean that challenges of this nature are available to a greater number of people. So that is to say, people who are affected by Direction 80 have not been granted priority under Direction 80, but when Direction 80 is amended or repealed in its entirety, will have applications that are continuing to be subject to a delay. So the importance of this issue has not gone without comment at the highest levels of government. So earlier this year, the Senate Legal and Constitutional Affairs Committee delivered a unanimous report identifying family separation caused by unreasonable delay as an extraordinary issue. I've set out a quote here: the committee heard deeply concerning evidence, of course, about the impact that this is having on people. There's a current audit being conducted by the Australian National Audit Office that's due to table a report in early February next year. And that's been brought about by correspondence from Julian Hill MP, of course, at a time that he was in opposition now, of course, and laying the problem at the feet of policies and processing priorities that were created by the previous government. But now, of course, it's a problem for the government of the day. So just with that background in mind, I'd like to introduce you to Zabi, who can talk in much more depth about what these issues mean for the community. Zabi, as I mentioned, is a human rights defender who's previously worked in Afghanistan with Physicians for Human Rights, specialising in forensic documentation of war crimes and serious human rights violations. Zabi currently works here in Victoria for the Victorian Foundations of Survivors of Torture, or Foundation House, and is the president of the United Cultural Support Incorporated and a committee member of the Victorian Afghan Associations Network. We're extraordinarily privileged to have Zabi's time today. So I'll hand over to Zabi to say a few words.
Thanks very much, Sanmati, for that. It's my pleasure to be here today and talk to you all. It is a very important topic for me myself. As you introduced, I'm heavily engaged with the refugee and asylum seeker community, and specifically with those who came from Afghanistan. On my job as I work with Foundation House, and also as a volunteer that I work with the community members who are going through a lot of the issues, which one of them are family separation and those who applied to be reunited with their family members. As you have mentioned, I've been engaged with the refugee community here in Australia for a long time, since the time I myself came as a refugee and as an asylum seeker, and it is very important to focus, especially those who have family members, immediate family members, and they are separated for years. And I, as part of my work that I've been working with the community and also at Foundation House, you remember last year when the Afghan government collapsed, and the community here were in distraught, and many of the clients that I work with, or community members who are not previously engaged with us, they were calling us, they were coming to our offices, even though there was during the lockdown, but they were distraught because they had many of them who came here as men, they had their wives and children stuck in Kabul, and many of them went to the Kabul airport as well, those who had application, and they were distraught, and they did not know what to do, and they were saying, my wife and my children are in danger, and they're at Kabul airport waiting to get in. And especially when there was an announcement that Australian government announced that we will take the additional 3,000 at the time, and also the Australian troops were in Kabul airport, and so there was a lot of panic and a lot of stress that those community members were going through, and it was we were feeling hopelessness too here, that we could not do anything other than provide them the information, as much information as we had. So that's, I'm trying to work with them on how to manage their stress and their worries and concerns that they had. But unfortunately, many of them, some of them were lucky to get their wife and children evacuated, but the majority could not. And they're still, and I have community members, I have friends and some clients whose wife and children are still in Kabul, living under the Taliban government, and they had their applications lodged years ago, as you have said. I'll give you an example of one of my friends that I will not use his name, his real name. We will call him Ahmad. He lodged and he came here as an asylum seeker in 2011, and he was granted a permanent protection visa. And later on, when he was able to apply for his, when he was not married at the time, but when he got married to someone in Kabul, as soon as he was married, he lodged an application, and his application was lodged 6 years ago. He currently has 2 children, his 2 daughters, and his daughter is, the oldest one is 5 years old, and he's still waiting. His wife and children are in Kabul, and he does not know how long it will take for them to get the visa. So that's one example of, and I've asked him and I've consulted with him many times. He does not have any, the application that he has lodged has no shortcomings. They have all the documentation, for example, the marriage certificate, the passport, the tazkira. So there's nothing outstanding. The only difference between him and someone else is that because he came as an asylum seeker by birth, and also because he's from Afghanistan, and so he's been waiting for 6 years up to now, and we don't know how long more it will take for his family to come and be reunited with him, and that causes a lot of his stress. So he's been living away from his children that were born after he lodged the application, and now they are almost going to school-age children, and that should not happen under any circumstances. So that's one example, but there are so many more that you guys are aware as you're working with clients. Some are waiting for longer than 6 years just on a spouse or a partner visa application, and many of them has no, there's no individual. I know sometimes when you talk to Department of Immigration, they say, oh, we cannot comment on those individual cases because there could be individual issues. But as far as I know, with many of them, there's no individual issues with their application. It's because, first, because they are from Afghanistan, and also because they came here by birth as an asylum seeker. So those are the only issues that are separating them from their family members. And as most of you know, I've seen, not in this wave, but previously when I came as an asylum seeker myself, families were separated for years, but not this long, maybe for 5 or 6 years then. And when the families are reunited, the issues that they have that they have to tackle with, because husband and wife or children and parents are separated for years, and they grow up without having their father or their mother, and that takes years to bond them back, and many social and mental health issues come with that. So it's not just this family separation is causing damage to the well-being and mental health of these families for long term to come, and we see many of them as clients at Foundation House. that's the primary, one of the primary causes of trauma and other mental health issues that they have to go through. So that's a short summary, but I will stay here if there are any additional comments. Looking forward to hear from Ben and others today. And thanks very much for organizing this important discussion today.
Thank you so much, Zabi. It's really important for all of us who are working in this space to understand the impact of this issue. So thank you so much for sharing that. We're also joined today by Ben Mostafa. Ben's a public and commercial law barrister at the New South Wales Bar. He's been at the bar since 2014 and has extensive experience in migration litigation. Ben is incredibly talented, and we at the Human Rights Law Centre have been incredibly lucky to work with Ben closely on a lot of our family reunion work, including a recent case challenging the minister's failure to make a decision on a partner visa application within a reasonable time. So Ben's going to speak to the legal principles underpinning the obligation to determine visa applications within a reasonable time, and the appropriate relief in situations where this duty isn't met. As mentioned, we've saved some time at the end of this session for some questions and answers. So if you've got questions for Ben as we go along, please just pop them in the Q&A as you think of them. Welcome, Ben.
Thanks very much, Josie. That's it's very kind. How have we got the slides? Yes. Am I controlling that? No. Okay. You can see from the slide, I'm going to address these 4 topics in order, and then I will touch briefly on relief, as Josie said at the end. We go to the next slide. We're just going to start with where the obligation to consider and determine a visa application within a reasonable time comes from. Now, good. I can click this. There's two points to consider there. The first is obviously it's an obligation that rests on the minister, and that being so, it comes from the Act. Section 47 of the Act obliges the minister to consider any valid visa application. You can see Section 51 on your screen there. That gives the minister some flexibility in terms of the ability to decide in which order the visa applications that are received will be decided. And you can see from subsection 51(2) that the fact that the minister might deal with a later in time application before an earlier in time one doesn't necessarily mean that the earlier in time one is found reasonably delayed. And the presence of those words in the Act itself tends to imply that there is that obligation, the obligation to deal with visa applications within a reasonable time. Section 65 then requires the minister to either grant or refuse a visa after he or she's considered it. If we skip, actually I can control this. We skip to the next slide. The High Court has made it quite clear that in the context of that Act, like any other Act that gives an administrator a duty to perform a task, but does not say when it has to be performed, it's implied that it has to be done within a reasonable time. You'll see the quote there on the screen. I'm certainly not going to read that out, but that is the key authority to refer to in terms of the existence of the duty. You can ignore the parts of that quote that suggest that protection visa applications are in a different class. That is because the Act used to provide a specific time within which they had to be decided. It doesn't do that anymore. So like family visa applications, protection visa applications also have to be decided within a reasonable time. So that's where the obligation comes from. The key points I think practitioners can take away from what I'm about to go through is that these topics you can see on the screen, they are the things you'll probably want to focus on when working out what about your client's case may help you establish an unreasonable delay, or what about your client's case might cause you problems in that respect. The first point, look for periods of inaction by the minister. And when I say look, I think Josie may talk a little bit later about FOI and things like that as to how you look. But when you have the information to you available about what the department has actually been doing, if you can established that there have been long periods of inaction when your client was waiting for the minister to do something, that's going to be of great assistance. I don't think it's of use if you're able to point to individual cases of other visa applicants that have been processed a lot quicker. And Section 51 of the Act, for example, shows why that is the case. However, it can be useful if you have information about overall or average processing times, and you can show that you've got an applicant who sits well outside that is likely to assist. We'll come to this issue about whether there's an outer limit, a sort of a hard outer limit in cases where there's no special circumstances. I think the answer is that there must be, but where it lies is not easy to say. And the last point is that because the individual applicants or indeed the sponsor's circumstances are relevant, if there are circumstances of hardship, when you come to litigate, you'd like to be able to show that those were communicated to the department early and they were communicated often. The department can be somewhat indifferent to these things. Showing that the difficult circumstances that a family is in have been communicated to the department and that's still led to indifference will position you well if you do end up needing to litigate to say that the department has acted unreasonably. We'll try and move reasonably quickly through these authorities. I'm certainly not going to read out the case names and so on, but and these slides I think will be published afterwards. So if you do need to come and find the authorities, you can certainly do that. You have to have regard to all of the circumstances of the case in determining whether or not there's been an unreasonable delay. That's clear. Those can include, the circumstances can include what's been described as the evident purpose of the legislation. We'll come to that in a little bit more detail in a moment. Whether it's been, the test has been said to be whether there are circumstances that a reasonable person might consider render the delay justified and not capricious. And that's, in that sense, it's quite easy for anyone really to form a view about whether in any given case something is likely to be unreasonable or not. If you can look at it and you're thinking, well, this person has given everything they need to the department and the department hasn't come back and said, well, we're missing this, we're missing that, they've just done nothing for 2 years, you start to think, well, what would a reasonable person think about that? They would start to think it's unreasonable. As I said, periods of activity and inactivity. And the last point on this slide, if a decision affects the liberty of a person, and this is it doesn't need to be in a visa context, any administrative decision affects the liberty of a person, that is a factor that must be taken into account when determining how long is a reasonable period for that decision to be made. Now, that in some ways can analogously be applied, and we'll come to how that works in a moment. I said ordinary processing times would be relevant. There is at least one case which has made reference to those, and it's made reference to them in the context of saying, in that case, there wasn't evidence to suggest that this person had been subject to delays that were too long. The implication being, if this is the delay that happens in the usual case, it's not going to be unreasonable. I think there's some force in that, but it's, as you'll see on the current slide, I think something that has a logical limit. And if you are faced with a situation where the government says, well, for all family visa applicants from Afghanistan, the standard time is 4 years, then in no way should that be accepted as, okay, well, we can't bring in a reasonable delay case until we get to 4 years or more. There's some authority you can see on the screen to say, well, doing nothing in the context of a citizenship application, doing nothing for more than a few months is too long. That's probably a bit difficult to run in a visa application context. But for the government to say, well, we just don't have the resources to move any faster than 4 years on applications for people from Afghanistan, I think that's unlikely to be accepted. The statutory scheme. Now, this is significant because in the case of, there are cases where the scheme, for example, as we said on the screen here for AQM 18 and section 501A of the Act, there may be cases where there's a public interest component in the exercise of the power, where the decision maker has to consider not just the individual circumstances and whether they meet certain criteria, but whether it's in the public interest. And the courts have said, well, in those kinds of contexts, you give the decision maker more leeway because they may need more time to consider those issues. Those don't seem to, at least to me, to be issues that would usually arise in a family visa application. The last case I've referred to on the screen is not a case about unreasonable delay in family visa applications, but it is a case about construing migration regulations. And in that case, a comment was made by the High Court, by some members of the High Court, that you would construe those regulations on the premise that it doesn't take so long to process a visa application that the underlying relationship between applicant and sponsor may rupture. That's a point that I think is worth making in any unreasonable delay case. And it's a point that really comes back to something that Zabi said. It seems to me to be inconsistent with the Act to say that it's reasonable for people to wait so long that by the time they're reunited with their wife and children, the relationship has been damaged, significantly damaged. And that, I would make that point in any case that you're bringing where you've got a delay of a number of years. Now, I'll deal very briefly with the last two topics. My time's running short. Onus. Technically, it is on you as the applicant to make out the case. But if you can show that there has been a delay such that it calls for explanation, e.g. those long periods of unexplained inaction, then the courts tend to say, well, that's it now, it's over to the decision maker to provide an explanation for this. And if they can't, you've gone a long way towards winning the case. Can delay after the commencement of the proceeding count? There's one lower court decision that does say no. I've referred on the screen there to DFE 16, which is a federal court decision, which leaves the point open. I must say, it seems to me to be difficult to see how it couldn't count. But that said, you're going to want to have a case that the unreasonable delay is crystallized before you start the proceeding. And the last point, which Josie said I would briefly deal with, was relief. Certainly the goal is to get the government to do something. Now, precisely how you frame it is it depends where you're up to. You can be concerned that if the visa application isn't grant ready, saying to the court you want an order that they decide it within 2 weeks, for instance, may actually backfire, because there may be some document that they say, well, ultimately, whilst we haven't processed this application, if we're going to do it in 2 weeks, we're going to need such and such document or such and such information. Be careful about not forcing them to reject the application because that's there. I would usually seek mandamus requiring them to process it forthwith or to process it without further delay. And if there then becomes an issue that they're not doing that, you can always come back to court and resolve that. So just be aware of that when framing your relief. And that's it. I think it's back to you, Josie.
Thank you very much, Ben. Thank you for whizzing through so much content so efficiently. I'm going to speak briefly about the Human Rights Law Centre's recent experience litigating for a family who were experiencing prolonged delay in their partner visa application. This is just an example. It's a case study. It's certainly not the only time that this sort of litigation has been tried. Many other people have done this, but because these matters seem invariably to settle, it's usually not public. So it's rare that we have an opportunity to talk about it in this way. In this case, our clients were really eager for their story to be known and shared, which was great. So the facts of this case were thus. The sponsor was a husband and father who had fled Afghanistan back in 2011. He arrived in Australia by boat and obtained permanent protection the following year. He arrived obviously prior to the introduction of fast track and temporary protection visas. When he fled, his wife and children remained behind, although they eventually were also forced to flee to Pakistan. For reasons that are no doubt common to a lot of families, they weren't able to apply for a partner visa until 2017. Now, by that stage, Direction 72 was in force. So because Dad arrived by boat, Direction 72 said that this family's application was the lowest priority for processing. However, they requested and were granted an exemption from the order of priority on the basis of some pretty harrowing circumstances that the family had been through. But even despite that exemption from Direction 72, nothing happened. So the family provided basically all of the necessary information and documents within about 6 months of lodgement, but the department just didn't lift a finger to process the application. Now, the lawyers who were assisting the family at that time and the family themselves did everything humanly possible to prompt action. But by the time we got involved, the visa application had been pending for over 4 years and was going absolutely nowhere. So steps that we took, we wrote a letter of demand to the department, which unsurprisingly, we did not receive a substantive response to. So we proceeded to file an application for judicial review in the circuit court. So we sought, as Ben mentioned, we sought an order for mandamus compelling the minister to forthwith take all steps to process the visa application. We also sought and were granted an expedited final hearing. So the matter was actually listed for final hearing about 4 months after we filed it. Despite this, we found it quite difficult to get engagement from the minister's lawyers. I think they assumed that this was just a run-of-the-mill judicial review application that they didn't need to think about for another 3 years. So we used a couple of different procedural tools to try and force engagement and get concessions from the minister on relevant points. So specifically, we sought to have the minister admit to various periods of inactivity on the visa application. So we used the notice to admit facts procedure, which requires the minister to respond within 14 days to deny something that you've put to them. Otherwise, they're taken to have admitted it for the purpose of the proceeding. This seemed to have the effect of nudging the processing office into gear. So after this all kicked off, the clients were issued with about 4 requests for further information in the space of about 3 months. So they had to do a lot of running around, doing their health and biometrics, character declarations, providing fresh evidence of the relationship, police clearances, vaccination certificates, the whole works. Now, while all of this was going on, the minister was refusing to admit that there were any periods of time in which there had been no active processing work going on. But there was simply no evidence in the court book, in the FOI, to suggest that the department had been doing anything to process the visa application. So we sought and were granted a subpoena for any documents underlying the minister's claim that something had been going on. Then the minister's lawyers actually called to concede the case on the day that that subpoena was returnable. It then looked like we might have a dispute about the appropriate form of consent orders to dispose of the matter. At that stage, we had responded to all of the requests for further information, but the visa application was stuck waiting for an overseas police clearance, which the processing officers insisted would not be waived. The minister delayed for a couple of weeks negotiating on consent orders to dispose of the matter, and eventually the visas were miraculously granted without that police clearance being provided. I think this really demonstrates the supervisory benefits of having a proceeding on foot, and reinforces that, the fact that an invitation to do health checks doesn't always mean that a visa grant is imminent. If we hadn't had this court proceeding on foot, I suspect that those requests for further information could have taken another 12 months or more to trickle through. So ultimately, the matter was discontinued after the visas were granted. It was discontinued with an order that the minister pay the applicant's costs on the ordinary basis, so not according to scale. And the family were obviously thrilled, and they were on the plane to Australia days later. And that was, a grand total of about 4 months after we filed the court proceeding. So, I mean, this example hopefully shows the strength of these actions when there have been prolonged periods of inactivity by the department, and I think also shows how quickly the department can move when they are compelled to do so. We do think that there is significant scope for more cases like this to be brought, as well as individual outcomes for visa applicants. You know, there's the chance that more frequent litigation could eventually force the government to properly resource the department and get processing times under control. I'll just talk now to some of the more nitty-gritty of running these kinds of proceedings. I'm going to really whiz through this because I do want to save time for questions. But, you know, picking the right cases is a little more tricky than just digging out all of the cases who have been pending for many, many years. There's a few things to look out for when assessing whether this kind of action might be possible for a family visa applicant. So the first thing to check is whether the application is reasonably grant ready. That obviously doesn't mean that every single piece of information has been provided and that health checks are done and all of that. It just means that there are no obviously missing supporting documents and that there are no outstanding requests for further information that the applicants or the sponsors haven't responded to. The second thing is to check whether the application is exempt from or not subject to Direction 80. This type of legal challenge that we're talking about is going to be a lot more clear-cut if the department, if the minister cannot point to Direction 80 as the reason for the delay. This is not to say that it's impossible to run one of these cases for a person who's impacted by Direction 80, but we might ask Ben to speak to that more during the Q&A time. And then thirdly, just as Ben mentioned, looking for cases where the delays are primarily attributable to the department rather than the visa applicant or the sponsor. Those are the procedural steps that we followed when we were running this case, though things can always be done differently. Our approach to the litigation was relatively aggressive because, you know, we were more than happy to go to hearing if we needed to. You know, one thing to note is that we did think it was quite important to FOI the entire file, including the department case notes before we issued proceedings. That allowed us to build a really clear chronology to see exactly what happened when and to see the times in which there'd been no active processing going on. I won't speak to the rest of those steps other than just to say that, yeah, it's good to be ready to assist clients with responding promptly to any requests for further information that you do get if you are going to file proceedings like this that might prompt the processing office into gear. There's a few ways that we foresee that matters of this type might unfold if they're filed. So the first possible outcome is the one which we experienced, which was that visas were granted prior to the final hearing. In that situation, we think that, you know, depending on the circumstances, the applicant's likely to have a strong basis to seek an order that the minister pays the applicant's costs. If the visas aren't granted prior to final hearing, that might be, you know, because the processing office just isn't in a position to grant the visas or to get it all sorted out before the hearing is listed. Then you'll be in a situation where you need to negotiate the appropriate form of relief. And Ben spoke about trying to make sure there's some ongoing court oversight in that scenario. The third possible outcome is obviously that there is no concession, that the minister doesn't concede and that the matter proceeds to hearing. We think this is pretty unlikely in most strong cases, but it could happen at some point, particularly if a lot of these cases start being brought. In the right circumstances, this could be a good outcome. You know, if we get a good judgment, that's potentially helpful for others. But even if a case loses, costs are obviously an issue, but the visa application does remain on foot waiting to be processed. So clients are largely back where they started. All right, that's it for me. I'll pass to San Martin now to discuss some of the specific risks and other considerations involved with this litigation. After San Martin's finished, we will move to questions. So please pop any questions in the chat. Thanks.
Great. Thanks very much, Josie. Sorry, I'm also going to rush through my remaining sections because we've got some really great questions coming through, as expected in respect of Direction 80, and also in relation to FOI, where there are also unreasonable delays, ironically. So let me just quickly get through this. So look, essentially, I wanted to flag, without discouraging anybody from, considering proceedings of this nature for their clients, just a couple of very obvious risks that arise from litigating these matters. The first and most glaring being the adverse costs risk to your client. That risk arises certainly, as Josie said, if the proceeding runs to hearing and is unsuccessful, but also potentially if the proceeding is discontinued. Although, as we saw in our case, discontinuance was on the basis that a cost order was made in our client's favour. So it's not always that clear cut, but it's something to keep in mind. In our proceeding, as Josie would have touched upon, we took the view that the matter had to be commenced by the visa applicant rather than the sponsor, because the applicant is the person who is the subject of the migration decision withstanding for the purpose of Section 486C, subsection 2 of the Migration Act. So the visa applicant would be the person, assuming that that's correct, which I'm sure it is. It's because it comes from Ben. But assuming that that's correct, the visa applicant would then be the person subject to the litigation debt. The upshot of that, of course, is that an adverse costs order will constitute a debt to the Commonwealth, which, in order to satisfy public interest criterion 4004, the applicant will need to make acceptable arrangements to pay, of course. Not necessarily to pay it off, but to at least enter into acceptable arrangements according to the Commonwealth. On the slides, I've just set out the scale of costs for migration proceedings at Part 2 of Schedule 2 to the Federal Circuit Court and Family Court General Federal Law rules. But what we have to keep in mind is that if the proceeding involves the type of non-standard steps that are outside of the course of normal migration judicial review proceedings, so such as various notices to admit facts and subpoenas and things of that nature, the Commonwealth may well seek costs outside of the standard scale. So that's something to keep in mind. The second issue, if we go to the next slide somehow, correct. The other risk, of course, as Ben touched upon, is that by commencing these proceedings, your client is going to necessarily draw attention to any potential deficiencies in their application, and also potentially bring to a head any underlying issues to do with the sponsor themselves. So as we all know, from 2014 onwards, the previous government introduced into the migration regime an increased focus on identity and ensuring the integrity of identity-related information given by visa applicants and visa holders. For the present purposes, there are two important additions to the regime to be mindful of. There's, of course, Public Interest Criterion 4020, paragraph 2, capital A, which requires that the applicant satisfies the administers to the applicant's identity. That was introduced by the Migration Amendment 2004 measures, number 1. And the second relevant provision is 116, subsection 1, capital A, which says that the minister may cancel a visa if he or she is not satisfied as to the visa holder's identity, and that was brought in by the Migration Amendment Character and General Visa Cancellations Act in 2014. The identity assessment itself and the process undertaken by the department has been separately the subject of criticism by the Australian National Audit Office. That is an entire other webinar that we might prepare for you. But the take-home message is that identity-related assessment undertaken by the department is notoriously defective. There are a range of ways that identity issues might come to a head. The department has a range of methods. It takes a so-called 3 pillars approach to the assessment of identity. It's based on narrative, biometrics, and documentation. So these are the 3 broad pillars. There are a range of things that the department can do to bring to a head identity-related concerns. They can engage in biometric comparisons, so a comparison of the kind of photographic evidence that the visa applicant or the sponsor is given in respect of the partner visa application, comparing that to biometric information, so pictures that they've got from previous applications. So say, for instance, the typical case where this arises is if the visa applicant was included in a much, much earlier humanitarian visa application for another family member in Australia under a different identity, then that's where the biometric chickens come home to roost. Other problems that could arise from forensic examination of the document itself, so the identity documents that are proffered by the visa applicant, and then so-called Five Eyes checks, so checks with other countries in relation to whether or not that visa applicant has applied, perhaps under a different identity, to migrate to another country. That all sounds very dire, but I suppose the view, optimistically, that we've taken is that because of, as Josie has mentioned, the very short span of these proceedings that we are given priority in the court, and the dysfunction that characterises the department's assessment of these applications, issues we would hope are not going to suddenly emerge upon the commencement of these proceedings that aren't already latent and sitting there in the file as it has been assessed up to that point. So that is to say, we hope and we expect that the department is not going to, upon the commencement of these proceedings, have the wherewithal to cook up an identity issue that they're not already alive to. Which again returns to the importance of forensically and carefully examining the FOI that you obtain to seek out those flags. So, for instance, looking through the internal ICSE notes or TRIM notes for anything that indicates that there has been a referral to, say, the National Identity Verification and Advice Authority, or NIVA, NIVA, or alternatively the Document Examination Unit, the DEU, anything of that nature that indicates that there has been a concern relating to identity, because that is a rabbit hole that the Commonwealth could then use to both justify the delay and also to bring about adverse consequences either for the visa applicant themselves or the sponsor by way of cancelling their visa. So again, as not to discourage you, we also take some comfort from, I might just go to the second slide if I can. We take some comfort from the fact that there seems to be at least a much less sort of dogmatic insistence when it comes to applicants from Afghanistan on providing the modern e-tazkiras and machine readable passports that had been issued by the Ministry of the Interior in Kabul since 2018. Applicants seem to be being granted visas without providing those identity documents or on the basis of paper-based tazkiras, which is heartening. There's also a section within the Department of Foreign Affairs and Trade's most recent country report on Afghanistan, which makes the obvious point that the Taliban are no longer administering the Ministry of Interior Affairs or maintaining the e-tazkira database, and there is no meaningful way for your clients to obtain those documents. It should be obvious, but at least DFAT has recognised that in the report. Another thing that we take some level of comfort from is that the overall grant rate for partner visas has consistently been exceptionally high. So over the past 5 years, it has hovered over 90%. And one thing that's particularly important to note is that according to the last financial year's program report, or the last program year's report from 2021 to 2022, the grant rate for partner visas was the highest in the past 3 years. So it's at 98%. And that is importantly the period over which there's been an increased number. There's been at least 1,500 partner visas granted to Afghan nationals. There's been some action on the types of cohorts that have previously been subject to delay. So that at least provides some comfort, but there is still, of course, as Ben and Josie mentioned, a reason to very, very carefully examine the information that the visa applicant has given, that the sponsor has given in the course of the application, to make sure that there are not any latent issues that you're going to be bringing to a head, either in terms of provoking visa refusal or bringing about the cancellation of the sponsor's visa, both awfully bad outcomes. So I think we're at 1:50. We've got 10 minutes for questions. I'm going to hand back to Josie now to go through the questions.
Thank you. Thank you. All right. Thank you, everybody, for sending through great questions in the chat. Ben, unsurprisingly, one of the first questions we've received relates to Direction 80. So I might read that one out and also just elaborate on that a little bit as well, on the question. So Direction 80 is likely to be repealed soon. We saw the minister's announcement last week. Hasn't happened yet, but will happen imminently. So if that's the case, why do we think that Direction 80 is still an issue? And if it is a problem, is it fatal, or is there still any scope to bring proceedings challenging unreasonable delay for people who are impacted or have been impacted by the direction?
Yeah, so Direction 80 was the third iteration of this direction. And we that is actually me and others, litigated the first iteration in the High Court. And after we put on our written submissions, that's when the government revoked Direction 62 and put in Direction 72, which was the predecessor to 80. You can go online and find the minister's submissions about that, and you can actually get from that a sense of how the minister would approach this kind of issue. It seems to be that the government accepts that the existence of a direction like Direction 80 doesn't do away with the obligation to process a visa application within a reasonable time. And I have to say that position seems to me to be unquestionably correct. That means that at the very least, the fact that you've got a client who is affected by Direction 80 as it currently stands, that doesn't preclude you from bringing one of these cases. If someone's been waiting a long number of years and the only reason why the application hasn't been processed, you may well have a decent case. The only way I think that the government may try and rely on Direction 80 is to say that the fact of that direction and the decision that sort of is embodied in it of deprioritising applications that are sponsored by, in essence, people who've come by vote, that is a valid thing for the minister to give weight to when deciding when a visa application is processed. That submission, I think, probably be accepted to some extent by the court, but it can only be carried so far. How far, we just don't know because no one's tested it. But if anyone has been waiting for a number of years, and that's the only reason why, there is a piece of litigation there sort of to be run, albeit perhaps not if Direction 80 is revoked. Once it's revoked, if you bring your application for unreasonable delay and you were affected by it, you still may want to make the point that it could not validly have given the government an excuse not to process your visa application for many years.
Thank you. One for Sanmati next. It's a great question. So strategic litigation is all well and good, but are there policy or legislative changes that we need to try to advocate for? Repeal of Direction 80 is one thing, but how do we change a department culture of obsession with identity and fraud? That seems like a longer term issue.
Yes, thanks, Marianne, for that excellent question. I suppose this type of legislation, this type of litigation that we're proposing is not strategic in the typical sense that it, kind of destroys an entire area or a culture of processing or things like that. We achieve individual outcomes, but hopefully en masse. The strategy of it is that it draws attention to much broader systemic issues that are absolutely endemic. There are a whole range of them. One of the obvious issues is that the department has, for a very, very, very long time, adopted arguably unlawful approach to imposing a de facto limit or cap in a way that does not have foundation in Section 87 of the Act on the number of family stream visas that could be granted per year. So that is to say the department is just randomly drawing a line in a way that is totally unlawful and without basis. Attention has been drawn to that over and over again. It was commented upon in the Senate Legal and Constitutional Affairs Committee. That is a systemic issue. The quality of decision-making in respect of identity is a diabolical issue that requires separate attention. Yesterday, I was talking with colleagues in the Refugee Law Reform Committee, hopefully some of whom are online. The failure to exercise or the rigid insistence on the provision of certain evidence that is literally impossible for people from Afghanistan to currently provide. So for instance, somebody was mentioning the example of a woman who's currently in Iran, but who was living unlawfully in Pakistan for some period, the requirement to go and provide penal clearances from Pakistan when it's physically impossible to get there, or to undertake health checks in particular circumstances, when these requirements are perfectly waivable, or alternatively, the insistence upon having a passport when that requirement itself is waivable, or there's a discretionary component inbuilt within all of that. So you're quite right. The strategic purpose of such litigation can only ever be to draw attention to these much, much bigger problems that are baked in to the department's approach to these cases. And they've been baked in, which is something that we haven't talked about. But the reason that this has become part of the culture is because there is family reunion is part of the deterrent stick that was intended to be deployed against asylum seekers who arrived by boat. And so this has been allowed to sort of flourish, and part of the broader work that we all need to do is walk that back, to draw attention to it and attack it from all sides. So I hope that answers the question.
Thank you. Another question for Ben, and Ben, I think this is something that we might have considered in our case recently. The question is, given the huge delays in receiving FOI documents, if you can't get your hands on those quickly, would you suggest filing a proceeding in circumstances where you're reasonably confident that there's been an unreasonable delay, and then perhaps filing further affidavit material down the track once you do get that FOI material back?
Yeah, I definitely would consider that. And I mean, you shouldn't have to wait to go through an FOI process. You're in a position where you're sure you've given everything over, and nevertheless you've had to wait, some unreasonable length of time. I don't see that there's necessarily a problem with commencing, and either upon commencement or not that long after commencement, issuing a subpoena or a notice to produce to the department to call for the file. There's you just run potential risk that if there is some explanation as to why this hasn't been processed, it may be that on the file something's been flagged and it's had to be sent off to someone to be investigated. You do run the risk that that's something you might not be able to know about, and you only find it out when you get the file, and it may cause you a problem at that point. If you do issue your subpoena or notice to produce early on, and it's answered early on, worst case scenario, if you think that the information that comes back means you need to withdraw, you can withdraw at an early stage when the costs are limited. That said, I mean, that's an unusual case we're talking about, and quite frankly, the position that some people are in may make it that they say that's a risk that's worth running. Those would be unusual cases where that eventuates.
Thanks. Maybe the final question that we can squeeze in is one for Zabi. Zabi, from your work in the community and with your clients at Foundation House, have you noticed any kind of patterns? Like, have you seen any improvements in the processing of family visa applications over either the last 12 months or since the change in government? Have you heard anecdotally about more people starting to be allowed to reunite with their families, or do you think that this is an issue that hasn't improved with the new government yet?
Thanks, Josephine, for that. There has been some progress in issuing family reunion or partner visas in the last within the last year or a bit more, and I don't think that relates to the change of government. But I have seen quite a number of families who have been reunited, and they have been issued visas within the last year. So there is some progress in there, but that's as you're all aware, that's not quite enough. There are many who are still waiting for years, but there is some hope, and that's good to see that some visas have been issued. Yeah, other than that, there is no there has been no explanation to the community either that why there has been some changes. So sometimes the community feel that they are in when it comes to immigration issues, there's a lot of misinformation and also lack of clarity from the department that causes those misinformation. So sometimes decisions happen without the explanation, or as we're aware, people from within same circumstances apply around the same time. Some get their visas years earlier, some wait for many years. So those are the general issues that the community don't have those information. But we hope that with the change of the new government, And as the department have promised that they have recruited more staff to process visa applications in general. Hopefully we will get more visas reunification, especially from countries like Afghanistan. As I've said, many of the visa applicants, especially the spouse or partner visa applicants, some live in other countries where their condition is not very ideal as refugees or as in many countries with no visas. But those who are living under the Taliban regime currently are there's quite concerns for their safety. So this I think there should be those who are from Afghanistan. The community's demand is that there needs to be a priority because lives are at risk, and every time there's an attack, especially attacks in Kabul and other places, relatives and family members of Australian residents or citizens get killed and injured, and many live in fear under the Taliban at the moment, in fear of their safety. So that's quite concerning for the community.
Thank you, Zabi. Absolutely. It's nice to know that there is hope for change, but there's still a lot of work to be done. Thank you all so much. I'm going to quickly hand over to Sanmati just to wrap up and talk about where we go to from here.
Thanks very much, Josie, and thanks for everyone who is still on the line, just 5 minutes over time, which is much less than I thought. We are keen to stay in touch with everybody. We have set up an email address. There are a bunch of questions. Libby, there's a question of yours that I didn't get to. I'm more than happy to be in touch after the session if anyone has unanswered questions. We are more than happy to share resources. Letters of demand, some other of the application material from our own proceeding, we're happy to provide that. If people are interested in practitioners are interested in bringing these cases themselves, please contact us. If you have clients who are looking for lawyers, please also contact us. Or if there's anything else, anything further from this, as we said at the start of the session, we're really hoping to build a community of practice around this issue because we think that something could be done. Both in terms of litigation, but as Marianne pointed out, much more strategically, this is an utterly unacceptable position for people to be in. So thank you very much for your time over lunch, and we will let you go, but look forward to hearing any follow-up questions on that email address there. So thank you very much.
Thank you all.